you're driving your friends home after a party, you've had a good time, and all of a sudden the police pull you over and arrest your friend. Maybe he's got some drugs on him or her. Maybe there's some drugs beside her. Maybe they did something else at the party, who knows? So that's a great question that people ask me. Am I criminally liable for my friend who's committed a crime in my car? That's a great question. We're going to break that down. And it's Mike Kruse from Kruse Law YouTube. And we try and break down common FAQ type questions in simple, plain language. So let's get right at it. And I'll go through some scenarios. Different fact patterns. We'll discuss the law here. It boils down to participation, intent, mens rea, guilty mind, and act, and whether you helped your friend or not, or whether you aided and abetted them under the criminal code. So let's explain those concepts in different ways. So let's take one way then. So you're driving your friend home, and you're pulled over. And let's say the police had a tip that that person is a drug dealer, and they search him and they find drugs in their pocket, like cocaine. Obviously in this situation, you didn't know about it. Obviously in that situation, you did not have knowledge, participation. You don't have a guilty mind, and you're likely not necessarily going to get charged. I suppose if the police charge you, it's an error, hopefully easily thrown out. So that situation, he clearly had possession and control of the drugs. Let me give you another situation. Your friend says to you, "Oh, could you stop off at this house?" And you would just assume it's a friend's house, and you wait for him outside, and you had no knowledge of anything, what's going to go on. So he goes in the house, and he commits a crime unbeknownst to you, and the homeowner reports your car. The police stop you. So are you going to be found ultimately responsible for that? Well, you had no knowledge. You didn't participate in it. You mistakenly assumed he's just stopping off at another friend's house, for example. But you might get charged in that incident, and hopefully you can win your case. But technically, you're not liable if those are the exact facts. Now, on the other hand, that's the getaway car type situation where you're aiding and abetting, and you weren't aiding and abetting, but the police might still charge you because they'll let the courts sort it out later. On another situation, if you knew that your friend was stopping to commit a crime, you're like the getaway car. So you've, under the criminal code, under section 21 and 22, you've aided and abetted them to commit a crime, essentially. So you're going to be charged. There's no question. And the courts are going to sort it out later because you had even if they didn't tell you what the specific crime was, if you had a inkling that they're going to commit a crime because they're dropping off at this weird house, you could be willfully blind. Or if they're telling you you're going to commit a crime, you're the getaway car. So that's a obvious situation. Now let's find another situation. So you're deemed, as the owner of the car, you're deemed to be in possession and control in that car and things in it generally, okay? So let's say there's a drug in the front seat beside you, and the police stop you, and it's in plain view, and they see that. But it's not your drug. It was your friend's drug. You never had possession and control of it. He brought it in the car. He just threw it in the front. That's mine. It's not yours. Don't worry about it. Well, the police are going to charge you in that situation and let the courts sort it out. Technically, there's two. The police have reasonable probable grounds. Now, you're not in possession or control of the drug, just like you wouldn't be in possession or control if the drug's in his pocket, but you're deemed kind of have to knowledge by the police. So you'll have to defend yourself and hopefully you win. If you're not believed, you might get convicted. You might, for example, your friend might turn on you and say it's your drug. So it's fraught with difficulty. I guess the moral of the story is don't associate with known criminals in that situation. But so those are common situations. A lot of times when there's drugs found in a car that are loose, they'll charge everyone in the car and let the court sort it out until someone comes forward. Sometimes people point the fingers at each other. Obviously, if that drug's in the glove compartment, it's probably yours and whatnot. But you can. So the answer to the original question is sometimes yes and sometimes no, you're liable. It depends on your knowledge, your participation, whether you aided, encouraged, or abetted. It's called aid and abet is encouraging really and helping a person do something. Obviously, you're a getaway car and you know that you're going to be liable. So there's all sorts of permutations and combinations where you could be guilty. There's others where you're not. sometimes when you're not guilty, the police are going to lay a charge. I think it's frustrating for people in a car who get pulled over and there's a drug loose and no one's taking responsibility. The police have to charge everyone. And it always looks like the owner of the car is somewhat guilty, even though you may not be. You may have no knowledge of it. So I hearken back to that. Know your friends and know who you're driving in a car with, okay? But the criminal code breaks this all down. So in order to be convicted of a criminal offense, you have to have mens rea, a guilty mind, and do an act. As an aider and abetter on a getaway car situation, you are doing both. You've got a guilty mind because you knew what the person can do. You're aiding them because you're there, and it's like a getaway car. But for other situations, you may not be liable at all. It really depends on each factual situation as to what your knowledge, your intent, and whether your level of participation. So you're not always responsible for everything that goes in on your car, but you have to know your passengers, let's face it, and be very careful of this situation. But I've represented so many people over the years co-accused in car when everyone winds up getting charged. And we hope someone comes forward to admit the offense. That's what often happens in that situation. I mean, it might be months down the road, someone comes forward, but I've also been involved in situations where everyone's pointing the finger at each other and it has to go to court. And then sometimes it's hard for the Crown to prove if the drug was, say, in the back seat beside a passenger. It's hard to prove necessarily against the driver, but this is all sorted out by the courts on credibility and liability. So there you have it. I guess the takeaway is know your passengers, be careful, and don't associate with known criminals, obviously, in a car. And, it's very important. So anyway, I hope you enjoyed our video today. And if you enjoyed the channel and enjoyed this video, please like it and subscribe it. And we look forward to seeing you on the next video. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.